friends, and welcome to another WSIB Truth Matters with Joe Machado on this beautiful Tuesday afternoon. I hope you're doing well. Today, I'm going to talk about a topic that has always been a good tool that I've used over the years with my firm and taught my staff to use it whenever possible. But I rarely see the WSIB apply it unless it's forced onto them or it's forced in their faces. Otherwise, they just go about their usual crappy attitude to deny just everything and anything that shows up. And this is the benefit of doubt section of the Workplace Safety and Insurance Act, specifically Section 119, subsection 2 of the Workplace Safety and Insurance Act, and it's covered in Board Policy 110113. However, it's not new. The benefit of doubt section has been a part of, as far as I can remember, the pre-1990 Bill 101 and prior legislations. And it was written into the legislation for a reason, and that was that legislators intended that if there was any doubt, or if a decision maker is looking at evidence and weighing evidence, that if that evidence is approximately equal in weight, then the benefit of doubt section should apply and benefits should be paid to the claimant. That's the injured worker. I can tell you that in dealing with the WSIB, both as an injured worker and on a professional level over the past 30 plus years, I built the largest paralegal firm in Ontario, dealing exclusively with the WSIB and, of course, Workplace Safety and Insurance Appeals Tribunal. And of the thousands of decisions that my paralegal firm and my staff and myself received over that period of time, I have never, not once, seen the WSIB apply the benefit of doubt section. They have applied it, and the only time that they did apply it was when we basically made the argument and shoved it in their faces and said, here, the law that you're supposed to adjudicate, implement, and abide by authorizes you to do just that. To get the WSIB decision makers, because they are the primary, I wouldn't say guardians, but decision making people. In other words, they're the first level. In order for them to apply this benefit of doubt clause, that would mean that they would have to approach decision making from the premise that they want to be fair and they want to be just to the worker, just as the legislators who wrote that section into the act. But as you have come to know, my friends, and as I have come to know over 30 years, the WSIB does not, in my experience, approach any decision from a position of wanting to be fair and just. They approach a decision from an arrogant standpoint and always placing the onus on the worker to prove whether or not he or she had an injury at work or developed a medical condition relating to their work. It's amazing just how adept they are in ignoring the law when making decisions. Just inexperienced, incompetent, I think a lot of both. So here's what Section 119, subsection 2 of the Workplace Safety and Insurance Act states. If in connection with a claim for benefits under the insurance plan, it is not practicable to decide an issue because the evidence for and against is approximately equal in weight, the issue shall be resolved in favor of the person claiming benefits, as you can see on the screen. That's what Section 119, subsection 2 states. I'm going to use a tribunal decision that I'm going to refer to because the tribunal, they are, for the better part, committed to following the law. Whether or not they're in agreement with it, there's often times that I've seen that they're not in agreement with board decisions and how the WSIB either created or implemented a policy that is not in line with the intent of the Act. They make that known, and the WSIB legally is supposed to make changes to that policy. So this decision has all of the classic factors that a case manager, an appeals resolution officer, anybody with the WSIB charged with making a freaking decision, all of those factors are here. So I picked this one, and it's a recent decision. So the decision, it's decision number 2018/17, dated January 4th, 2018. I'm going to put certain sections up on the screen as I refer to it. And so in this particular case, as you can see, the history of accident, the worker was injured on June 20th. He experienced acute low back pain stepping down from a truck while he was at work. Employer's first aid report states that the worker complained of pain at a level of 5 out of 10 in the lower left side of his back, radiating down his left leg, very limited range of motion in all directions, and no position would lessen the pain. He iced his lower back for about 15 minutes on and off. He was advised to seek medical help if the pain was too great or worsened. He was given restrictions for the remainder of the shift, so he was at work. And the following day, he was seen at the emergency department of the hospital, and he provided the accident history of pain getting out of the truck. Further medicals described it as a severe sharp pain, and the diagnosis that was made at the hospital was lumbosacral strain. So as you can see from the history here of the accident that was reported to both the employer and the emergency department right at the time that it happened, with the employer, and the very next day with the emergency department, the history of hers was very consistent in terms of what happened, what he was doing when it happened, his symptoms, and where he was at. More importantly, he was at work. So the claims adjudicator calls the worker to clarify some information, and so I'm gonna refer to that conversation here. So the board claims adjudicator telephoned the worker on July 2nd, 2010. The worker told her that when he got out of the truck, he had a sharp pain in his lower back, numbness in his leg, and he nearly fell to the ground. The worker could not attribute the injury to a specific action or event beyond descending the stairs of the truck. The Form 7, that's the employer's report, which is dated June 14, 2010, the day that the injury took place, describes the employer's understanding of the accident as upon exiting the vehicle, he felt immediate pain in his back, also consistent with his reporting. However, the Workers' Form 6, dated July 8, 2010, contains the Workers' Form 6 is the worker's report of the injury, contains a reference to twisting. it states, as I exited the company truck on the passenger side, I twisted my back, felt a sharp pain down the left side of my back and my leg became numb, and I could not walk. Then off to medical. This is the first reference to twisting. This is what the case manager is saying, or the claims adjudicator. Well, sometimes that happens. It's normal. Sometimes you may say something or write something that is within the construct of what actually happened, and there may be one minor factor. Twisting, bending. I mean, come on. The bottom line is the reporting that he made to his employer on the day of the injury to the emergency department the following day, and on the Form 6, with the exception of the twisting, was consistent. And if the case manager was really interested in being fair and trying to address that one specific point, perhaps the further inquiries could have been made. But that didn't happen because, as we all know, the claims adjudicator wasn't really looking to allow entitlement in this claim. Because up until this point, the evidence for is far outweighing the evidence against, which is that one minor detail. The scales are not even balanced. So in an attempt to clarify this, the workers' representative, whom I believe did an awesome job, very knowledgeable, and pointed out key factors, wrote a letter to the claims adjudicator. And in his letter, he states, in a letter from Mr. Ladouceur to the board dated July 9, 2010, he refers to one of the stressors that likely caused the worker's injury as, quote, the twisting motion while exiting the truck, end quote. In a further memo dated July 20th, 2010, the claims adjudicator elaborates on her prior telephone call of July 2nd, 2010. She describes the facts referred to by the representative in his letter of July 9 as constituting a changed accident history. Holy shit. She described that the worker had told her in the prior telephone call that, quote, he just got out of the pickup truck and felt severe pain in his back, end quote. Claims adjudicator states that he denied heavy or unusual activities, of course, because he didn't have any. It wasn't reported. Prior to getting into the truck, awkward movement or twisting getting out of the truck, or slipping or stepping out onto uneven ground. I don't know where she got that. I guess she just decided to color her memo with useless information. Anyway, she goes on to state she denied the claim on the basis that the symptoms were likely due to underlying degenerative changes. I note that the family doctor's initial diagnosis was of disc herniation, which, according to the Tribunal Medical Liaison's office discussion paper on back pain, can sometimes be related to trauma, but can also be a degenerative in origin. Again, I don't know where she came up with that. Anyway, she goes on, the letter from the representative, he goes on to state, in a further letter dated August 3rd, 2010, Mr. Ladouceur accepted that twisting was not referred to in the earliest reports of the injury, but referred to the board's adjudicative advice document entitled Initial Entitlement, in brackets, Disablement, which states that the fact that a worker cannot immediately associate the problem / pain with the work activity, or that the activity is not different, is not itself a reason to doubt the validity of the claim. The claims adjudicator went on to deny the claim. Of course, Mr. Ladouceur basically shoved it in her face, one thing which was basically to indicate that, hey, this is a disablement. And so you have to rely on the balance of probabilities to make a determination as to whether or not it is more likely than not that his motion as getting out of the truck, as he explained, that therefore caused the back pain, is more likely than something else, that the injury or the condition resulted from his work. And any experienced adjudicator would have been able to do that and pick up on that. And even if the adjudicator was inexperienced or had his head shoved up his ass during that time, an experienced appeals resolution officer should have picked up on that and should have considered it, and certainly, at the very least, should have considered Section 119, subsection 2 of the Workplace Safety and Insurance Act, which is the benefit of the doubt clause. But no, neither of them did that. They didn't think that they should consider those two factors, which could really make a big difference. And if they had looked at the decision making with the premise that they wanted to be fair and just, they would have done that. So, inevitably, and as I see often, and it always puts a smile on my face when I see it, is when there's a vice chair who makes a decision and basically shoves it in the appeals officers and the claims adjudicators' faces and any other idiot at the WSIB involved in a decision to demonstrate just how inept they are and how negligent they are at applying the law, their law. So the vice chair, this is what he decides. So basically he goes on and he states, I have allowed the appeal on the benefit of doubt. I have two concerns about how the ARO, that's the appeals resolution officer, approached the issue. First, in his final determination, he states, I am not convinced the worker's employment contributed to the onset of the low back, left leg symptoms on June 14, 2010. The vice chair states, the legal test is not whether the decision maker is convinced, in quotation marks. That phraseology denotes the test of a clear and convincing evidence that was once defined in the line of tribunal decisions as the appropriate test to rebut the presumption when the presumption applied, which the presumption did not apply in this case. It has never been the legal test applicable to the situation in which the presumption does not apply. The test in that circumstance is the balance of probabilities, subject to the benefit of the doubt. In my view, the test to be addressed is whether it is likely as not that the worker's activity of stepping down out of the truck was a significant contributing factor in the severe strain. That test reflects the legal standard of the balance of probabilities subject to the benefit of doubt, which, by the way, neither the appeals resolution officer or the claims adjudicator bother themselves to do, as pointed out by the vice chair. And he goes on to state, it follows that the second respect in which I disagree with the analysis of the appeals resolution officer is that he has failed to address the benefit of doubt provisions of the Act. The benefit of the doubt provisions of the Act are generally applicable to all claims for benefits determined by the board, irrespective of whether the presumption applies. It should, as the vice chair pointed out, almost be a default position that presumption of applying that benefit of doubt clause should always be present in the line of thinking of a claims adjudicator or appeals resolution officer when they approach a decision-making process and they're trying to be fair and just to the worker. It's bullshit. It's enraging sometimes. You put yourself in a person's shoes. You got to wait years to go through their bullshit process to get to the tribunal to have somebody apply the same law, the same sections to the law, the same policies in rendering a decision that could have and should have been rendered by the board. It's outrageous. And yet these people are allowed to continue to go on just screwing the worker. As you can tell, friends, shit like this bothers me. Which is why soon enough I'm going to be launching a segment of my channel that I will be employing in my videos. And it's titled, appropriately titled, The Shit Show. So don't be surprised when you see that on one of my thumbnails or a post, because I'm going to comment on the shit show and the totally and completely lack of compassion, understanding, the wanting to be fair, a lack of experience, and just outright negligence on the part of the WSIB. And I think you'll find it interesting. So anyway, friends, if you're already subscribed to my channel, thank you. I appreciate it. It's really helped to grow the channel. And I do appreciate you sharing my videos. If you're not yet a subscriber, I invite you to become a subscriber to my channel. It's free. All you need to do is click the subscriber button, click the notification bell. You get notified every time I come out with a new video. In just under 5 months, I've done 70 plus videos. I have over 30 years of experience dealing with pre-90, Bill 162, Bill 99 claims and legislation. I can talk on a number and a variety of different issues. And my goal is to touch every injured worker in the province, past and present, who have been affected negatively by the WSIB, that are having problems and need help. My channel is going to serve as a way for me to be able to talk about these issues and provide solutions. But above and beyond that, I've created a company, WSIBsettlements.com, and I created a series of tools and documents that I've used over the years that are successful, that have been successful in the past, to help injured workers succeed in their claims for benefits. And we have a lot to offer there. So if you would like to have a look and see if it's something that's for you, I appreciate that very much. And as always, my friends, I thank you for taking the time to watch my videos. I appreciate you sharing them. And if you have any questions at all about this subject or anything else going on, please send me an email at joemachado@WSIBsettlements.com, and I'll respond to you and provide whatever information I can and experience to help you. All right, friends, as always, take care, friends.